Dominic, you're on.
Chairman, with your permission, we can begin the meeting? Thank you. Again, please remember to mute your phone until you're prepared to speak. Bob, Deneen, please generate the roll call.
Chairman Beiser.
Here.
Commissioner Brewer.
Here.
Commissioner Davis.
Here.
Commissioner McKelvey.
Here.
Commissioner Reyes.
Here.
Commissioner Sandberg.
Here. Thank
We
you.
have a quorum.
Thank you. Good morning. My name is Dominic DeSera, Executive Director. Joining me are the following staff members: our General Counsel, John Gay, Michael Belmonte, our Director of Mutuals and Wagering, our Project Manager, Bob Deneen, and moderating this WebEx is Donald Marquez. Today is Thursday, January 21st, 2021. We have assembled a platform for us to conduct today's monthly board meeting by WebEx in order to attend to industry matters, comply with executive orders, and safeguard our racing community. This meeting is being conducted remotely pursuant to Public Act 101-640, which amended Section 7 of the Open Meetings Act to permit remote meetings when certain conditions are met. The Governor has issued a disaster declaration due to the circumstances related to the COVID-19 pandemic. I, as the Executive Director of the Illinois Racing Board, find that conducting an in-person meeting is not practical or prudent because of the disaster. All members of the Illinois Racing Board have verified they can hear this discussion and testimony. Members of the public are able to hear the meeting contemporaneously via the Illinois Racing Board website. I, along with General Counsel John Gay, Michael Belmonte, Robert Deneen, and Donald Marquez, are present at the Thompson Center. All votes will be conducted by roll call. Notice of the meeting was posted prior to 48 hours before the meeting, and a verbatim record of the meeting is being recorded and will be available to the public. The meeting is being transcribed, and oaths and affirmations are being administered in compliance with Executive Order Number 12. Please remember, when speaking, you must state your first and last name. Chairman, we'll begin with the agenda item number 1, which is public commentary. This office has received no request to speak for the public commentary period, so we can proceed to number 2.
Item number 2.
Agenda item number 2, request submitted by HAWTHORNE Race Course for approval of racing officials. HAWTHORNE Race Course requests approval of racing official Jesse Campbell as clerk of scales. Jesse was a longtime rider in Illinois and National Racing Circuit and rode for many years at Hawthorne. Jesse is familiar with all the riders and personnel in the jockey's room at Hawthorne Race Course and has been previously approved by the state stewards. Staff recommends approval. Chairman, there's a representative from Hawthorne on the line. Should the board wish to speak to anybody?
If they'd like to, go ahead, yes.
This is Ben Reyes. I want to move this item.
Okay, we have a motion by Commissioner Reyes. Do we have a second?
I'll second. This is Leslie Sandberg.
Second by Commissioner Sandberg. Please call the roll.
Chairman Beiser.
Yes.
Commissioner Brewer.
Yes.
Commissioner Davis.
Yes.
Commissioner McKelvey.
Yes.
Commissioner Reyes.
Yes.
Commissioner Sandberg.
I vote yes.
With a 6-0 vote, the motion passes.
Number 3.
Thank you. Agenda item number 3. Request submitted by staff for approval of contracting goals for 2021 organization licensees pursuant to Section 12.2 of the Illinois Horse Racing Act. Section 12.2 of the Illinois Horse Racing Act, titled Business Enterprise Program, authorized the board to promulgate rules for establishing goals for the award of minority contracts by each organization licensee. IRB Rule 425.20 requires each organization licensee to submit to the board proposed contracting goals for minority-owned businesses, female-owned businesses, and businesses owned by persons with disabilities. For each calendar year, the board shall establish contracting goals for each organization licensee. The rule further states that the board shall not establish any type of quota in connection with the enforcement of Section 12.2 of the Act. At the January 2020 meeting, the board approved the following contracting goals for 2020. 11% shall be awarded to businesses owned by minorities, 7% shall be awarded to businesses owned by females, and 2% shall be awarded to businesses owned by persons with disabilities. These percentages were taken from the Business Enterprise for Minorities, Females, and Persons with Disabilities Act. The organization licensee submitted the following actual spending percentages for 2020 as well as proposed goals for 2021. Arlington International Race Course. For minority-owned businesses, 1.4% actual for 2020 and 5% proposed for 2021. Female-owned businesses, 14.9% actual for 2020 and 15% proposed for 2021. And businesses owned by persons with disabilities, 0.5% actual for 2020 and 1% proposed for 2021. For Fairmount Park, minority-owned businesses, 4% actual for 2020 and 11% proposed for 2021. Female-owned businesses, 11% actual for 2020 and 7% proposed for 2021. And businesses owned by persons with disabilities, 0% actual for 2020 and 2% proposed for 2021. Hawthorne Race Course and Suburban Downs. Minority-owned businesses, 6.5% actual for 2020 and 20% proposed for 2021. Female-owned businesses, less than 1% actual for 2020 and 6% proposed for 2021. And businesses owned by persons with disabilities, 0% actual for 2020 and 1% proposed for 2021. To comply with Section 12.2 of the Act and Part 425 of the Illinois Administrative Code, staff recommends the following contracting goals for 2021 for each organization licensee. Minority-owned businesses, 11%. Female-owned businesses, 7%. And businesses owned by persons with disabilities, 2%. The Illinois Racing Board will continue to monitoring of actual results and work with these racetracks to meet or exceed goals in each category. Staff recommends approval.
Do we have any questions or comments from the commissioners?
Dan, this is Leslie Sandberg. I have
Sure.
a comment as kind of the new kid on the block.
Please do.
I read through the Act and all of the reporting for the last couple of years on this, and there's some great information included in that, but it does occur to me that there's probably some assist we could give without getting too deep in the weeds or too operational in terms of helping all the people report the same kind of information in a format that would make it easier to be clear on how we could help or how they can be helped to achieve their goals a little better. Like I said, it's not an operational thing I'm suggesting, but as a commentary, I think there's probably some stuff the board could look at, or staff really, because this will fall to the staff, to see if there's a way we can help give them some structure in terms of the reporting.
I appreciate the comments, and I will acknowledge that Commissioner Sandberg has, we've had some discussions in the last, between myself, I've been involved, Dominic, John Gay, and others have been involved regarding this item, and Commissioner Sandberg's offers some good perspectives moving forward, how we could refine the process in a helpful manner for each licensee in regards to this. So I appreciate that, and we look forward to moving forward with that.
I had one comment. This is Commissioner Davis.
Please do.
The actual numbers, and particularly for minority businesses, they seem to fall well below the goals that were set. And so I'm just curious from each track, what do they attribute this to, and sort of what are they doing to implement plans to help achieve some of these goals that we set. And I understand it's not going to be actual, but they seem to be not coming close, and particularly for minority businesses. Are we not getting the number of contracts, or what's the process?
Commissioner, we have representatives from each racetrack. Once sworn in, they can answer to your question. Whom would you like to call up first, or whom would the chair like to call up first?
I'm open to any order that presents itself.
So the first order we called up was Arlington International. I believe Tony Petrillo is on the line. Can he be called up, sworn in, and we can begin testimony?
Good morning, Tony Petrillo, Arlington International Race Course President. I'll be sworn in.
You're muted, Lydia.
Do you solemnly swear the testimony you're about to give in this cause will be the truth, the whole truth, nothing but the truth?
I do. Good morning, Mr. Chairman and fellow commissioners, and just Commissioner Davis, to answer your question. Arlington, over the past 2 years, has worked with the Latino Caucus and soliciting vendors, minority vendors, at their annual conference. That conference was canceled in 2021, so there's a little bit of a gap there. We've also worked with state representatives that are representative of the Black Caucus and trying to solicit minority vendors, as well as some regulators that have provided us references in helping us identify minority vendors. So that's where we've kind of reached out on more of a grassroots rather than any broadcast of, or publications, I should say, on our website. That did not prove to provide enough references for us. So again, we've reached out into a kind of a grassroots way to be able to solicit vendors to be able to help improve those numbers and award contracts, on a proportionate basis. Some of the contracts that we have are very small, so we may have a number of minority or vendors that fall into these categories, but it's not the one contract that may be a little bit more on something like that. We provide paving services and so forth that have a little bit higher dollar value to them, so those numbers can get skewed a little bit.
Understood. Thank you, Tony. I'm just really just trying to understand the process of how it works and how businesses are solicited.
Yes, and when we're happy to take any references in from any resource that anyone may have available to us. Especially now, the timing would be prudent as we work towards our opening at the end of April.
Thank you. Sounds good.
Thank you, Commissioner. There's Ms. Helton, a representative from Fairmount Park, is also online and available to provide testimony. Please be sworn in, Ms. Helton.
Hi, I'm Melissa Helton. I can't see you, but if you can raise your right hand, do you solemnly swear the testimony you're about to give in this cause will be the truth, the whole truth, nothing but the truth?
I do. Just being my first year here at Fairmount Park, digging into everything, with all practices, the purchasing area was not previously tracked as it should have been. So this year, in fact, I'm implementing now, and we're hiring a specific purchasing manager that will help with this goal of meeting all of these categories. And I'm used to that, most of you all know my background is casino, and you have to do that in the casino industry, and I was kind of surprised that it wasn't done here in the past. But already we're working on it. We're getting a form together that we're sending out to our current vendors so that we can upload them in our system and have better tracking numbers.
Thank you, Linda. That sounds great.
Thank you. There's a representative on the line from Hawthorne. Please be sworn in, Mr. Walsh or Mr. Miller. I don't know who's going to testify. On your behalf?
John Walsh.
If you could raise your hand, please, to be sworn. Do you solemnly swear the testimony you're about to give in this cause will be the truth, the whole truth, nothing but the truth?
I do.
Thank you.
When we put our goals together for this year, we figured we would be under full construction in the casino. And so, as you see, some of the numbers did go up. But with the construction actually starting in 2021, we expect to hit all of our numbers. We've got a mandate to have minority and female contracts as well as disability people. So we're working on that. We've got a whole plan. So hopefully 2021 we'll be able to hit all the numbers that we put up there. Thank you.
Thank you. I personally appreciate the comments, and we do look forward to some of the numbers, rising in these areas. Thank you.
Are there any questions or comments from the other commissioners?
Yeah, Ben Reyes, I have a question for Fairmont. Last year, you're showing that the women-owned businesses were at 11%, and then you're proposing a lower number. Would you be doing less business or more business?
No, that will drastically change and go up on all categories.
Okay. Yeah, because it would be a shame to reduce the women-owned business from 11 to 7 after you've had such a good year with them. Okay.
No, I promise you, all of them will go up.
All righty. Thank you.
You're welcome.
Further questions? Hearing none, do we have a motion for approval?
Leslie Brewer, motion for approval.
We have a motion. Do we have a second?
Ben Reyes, second.
A motion and a second. Would you please call the roll?
Chairman Beiser.
Yes.
Commissioner Brewer.
Yes.
Commissioner Davis.
Yes.
Commissioner McAlvey. Commissioner McAlvey.
Are you muted, sir?
No quorum.
Yes.
Commissioner Reyes.
Yes.
Commissioner Sandberg.
I vote yes.
The 6-0 vote, motion passes.
Item number 4.
Thank you, Chairman. Agenda item number 4. Request submitted by staff to certify first recapture authorized under Section 26G13 of the Illinois Horse Racing Act. Section 26G13 of the Act provides that the board certify in writing the amount a recapture eligible wagering facility is entitled and a schedule for payment of the purse recapture amount. The Act further states that the board certification shall be provided no later than January 31st of the succeeding year. The Act provides that if the total Illinois handle on Illinois races in any calendar year falls below 75% of the total Illinois handle on Illinois races of the calendar year in 1994, then any individual wagering facility, racetrack, or OTB that handled less than 75% of its 1994 base year is entitled to deduct 2% of the difference. Each wagering facility's board-certified purse recapture amount is deducted from the racetrack's purse account from which the facility derives its license. In the event a wagering facility is affiliated with a racetrack that maintains purse accounts for both harness and thoroughbred racing, the amounts deducted from each purse account is prorated based on the wagering facility's handle on each breed. Under Section 26G 7.1 of the Act, the recapture certification for Fairmont Park applies 20% of the recapture that would otherwise be paid from the harness purse account to the Illinois Colts Stakes Fund. The remaining 80% is paid from the thoroughbred purse account at Fairmont Park. Following recapture amounts are to be certified. Arlington Park, $4,948,020. Hawthorne Race Course Thoroughbred, $2,879,530. Hawthorne Race Course Harness, $2,320,525. Fairmont Park Thoroughbred, $1,250,000. $1,934,464. Fairmount Park, Illinois Colton Stakes Fund, $44,437. Total 2021 recapture, $12,126,976. Staff recommends approval of first recapture certification. Chairman, there are representatives from each licensee that are able to answer questions from the board. In addition, we had a request to speak on this topic from the representatives of the ITHA. So, at your schedule.
Let's hear from the enforcement, please.
Good morning, commissioners and Mr. Chairman. This is David McCaffrey. Would you like to swear me in?
If you could raise your right hand, please. Do you solemnly swear the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So, realizing that probably half of the new commissioners are new, I just wanted to give a little bit of a recap over what recapture is, some of the effects that it's had on us, and a couple of their comments. This year, 2021, sadly marks the 25th anniversary of this unconscionable law that was passed back in 1995. It's a law that was added on to in 1999, and the add-on was a solution to the problem. So the state recognized that it was a problem, and the state passed a law correcting the problem. And the solution was that the state would reimburse the amount. So Dominic explained the law terrifically in terms of how they get to the numbers to certify. But after that, there's essentially three parts of the law that unfolds. The first part is that the racing board certifies the amounts. The second part is that the racetracks take the amounts from the purse account. So let me backtrack a little further and say that every dollar that gets bet on races, there is a waterfall of what happens to that dollar. Most of the dollar, because it's pari-mutuel racing, gets returned back to the bettor. And then other parts go to the state, other parts go to the racetracks, and other parts go to the purse account. And in theory, the split between the racetracks and the purse account is 50-50, in theory. And that's, kind of what happens. But then, that 50-50 has a big asterisk behind it, and the asterisk is this issue, recapture. Because this law allows for the racetracks to dip into the purse account, the money that was generated for the purse account, and move it from the purse account side to the racetrack side. And when the law was initially passed, some of the testimony back, sadly I remember this 25 years ago, some of the testimony given at the time of it was, it probably won't even come into effect, and if it does, the effects will be minimal. So it passed, and then the next 5 years unfolded, and it became so problematic that the state steps in and adds on to the law. And that part of the law that's also in 26G13 reads, annually, the General Assembly shall appropriate sufficient funds from the General Revenue Fund to the Department of Agriculture for payment into the thoroughbred and standardbred horse racing purse accounts at all Illinois pari-mutuel tracks. The amount paid to each purse account shall be the amount certified by the Illinois Racing Board in January. So again, three parts of the law. The Illinois Racing Board certifies the amount, the racetracks take the amount, and the state reimburses the amount. Sounds beautiful. Problem is, the third part of the law hasn't been followed since 1999. And when I said it was unconscionable, let me give you some figures. After today's certification number for Arlington, they will have received from this recapture law $98 million. $98 million. Now, this isn't in any way an attack on Arlington. They're following the law. But it shows the effect of how bad this is for the persons. $98 million. Collectively, since 1995, doing the quick math after getting those numbers, the total recapture number for Arlington, Hawthorne, Fairmount, and Maywood and Balmoral, believe it or not, is $298 million. So almost $300 million has been taken from the purse account. That money was earned for persons, has been taken from that side of the ledger and given and taken by the racetracks. And, you know, I assume everyone on this call knows the shape of Illinois racing. There's been nothing more damaging to Illinois racing and the dissension of it than this recapture law. In 1996, there were over 12,000 licenses given out by the racing board. In 2019, we're down to 3,800. The number of thoroughbred foals born in 1995, believe it or not, were 1,243. Last year, that number, 1,243, descended to 165. I mean, it's like the transverse of decimated, which is a drop of 10%. This is a drop of almost 90%. The horse race dates that horsemen can race for in 1996 were 400. This year, we're looking at, on the thoroughbred side, 118. And purses, which is the economic driver of the sport, in 1996 were $83 million. Purses, I'm not going to mention what they were last year because it was such an odd year relative to COVID and the purses just got crushed. But purses in 2019 dropped to $21 million, $83 million to $21 million. Again, recapture being one of the main causes for those declines, for all of those declines. But it's the law, right? It is what it is. And unfortunately, the state of Illinois is not doing its job and not following the law that requires them to reimburse this money. So that's just a little history of this and why it is such. You've probably heard that it's such a hot button issue, and those are the reasons that it's a hot button issue, because those numbers are staggering, I think, by anyone's judgment. So relative to this year, Hawthorne Race Course, recognizing how bad recapture is deferring any collection of it until more money is generated for their purses when their racino gets up and operational. We have a contract with Arlington Park that speaks to recapture and plays an integral role in some of the calculations that we do at Arlington Park. The only request that we have goes back to the September dates hearing, during which we said, you may remember, we said, okay, we have a concern that Arlington may not race all 68 of its days. We're hopeful that they will. I think that I'm 100% positive that they're hopeful that they will. However, look what happened this year with COVID. And you basically can't count on anything. So the only provision that we wanted put in the dates order, as you may remember, was a provision that said Arlington can only collect its recapture if they race their 68 days. And for whatever reason, that it was said that the September meeting wasn't particularly the meeting to take up recapture issues, but that was certified in January. So all our request here is we're not disputing the numbers, we're not disputing the law, although only 2/3 of it's being followed, and the one that's not being followed is the one that's harmful to us. But we would like a provision put in that just says that the money for Arlington, the recapture money for Arlington, gets put into a side account and is held. And once they've raced their 68 days, then they can get it. If they race their 68 days, this provision, this request, would have zero bearing on anything. It's only if they don't race their 68 days that it would come into play. And that's basically our presentation.
Dominic, do we have anybody else to speak before I ask the commissioners for their comments or questions?
Before I answer your question, Chairman, I'll ask Mr. McCaffrey if anybody else from this group who did request to speak will be adding anything, or we can move on.
Yeah, Mr. Chairman, this is Mike Campbell. I'd like to make a few comments.
Sure, go ahead.
Should I be sworn in, sir?
Yes, you're muted, Lydia.
Can you hear me now?
Yes.
Okay. If you could raise your right hand, please. Do you solemnly swear the testimony you're about to give in this cause will be the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Well, thank you, commissioners and Mr. Chairman and staff. You can see how emotional of an issue this is for the standardbred industry and the thoroughbred industry. The takeaway, as stated by David McCaffrey, is real. It is harmful. It is what has caused the almost total erosion of the industry in Illinois. The satisfaction of this, the solution, is twofold. It's the gaming bill that passed, and of course the solution was provided for in the gaming bill that a gaming license for gaming at the track at Hawthorne and at Fairmont Park eliminates the need to take away of recapture. Arlington, Churchill Downs, and Arlington Park has chosen not to implement that license. And so the future there, we don't understand at this point, but we will certainly by next day's hearing. So my point is this, that we do thank Hawthorne very much. We have north of a $5 million overpayment to deal with at Hawthorne. Contractually, we have made an agreement with them to pay that money back on very generous terms. And their focus is on racing, and we're happy that it is. We don't know what to do here other than to object to recapture because we see what effect it has. If Hawthorne had chosen to take out their recapture last year in its entirety at $5 million in an overpayment, we would have been giving 90% of the purse money back to Hawthorne, and we would have been racing for around $13,000 a day. And that's just untenable. So we depend on the tracks to work with us and hopefully defer some of this recapture. We hope that they do. Those that won't, it's their right. It's their legislative right. But at the same time, it doesn't mean that it's a good law. And so our greater concern right now is preserving the entirety of these meets, particularly at Arlington Park. If by Labor Day, COVID plays a role, or if handle is not what it should be, and they have done all that they needed to do in the prime of that meet, we just hope that they continue that meet, because the horsemen at that point would have no place to go if that meet were to be shortened. So we'd like, the commissioners to be aware of this. We talked about it in September. We realized many of you are new, but contingencies at this time would guarantee a solution to the integrity of the entire racing calendar instead of a partial solution. So with that, I thank you. We understand the difficult nature of this and following the law. I don't think anybody likes it anymore. We look forward to a permanent solution to end recapture in Illinois, and therefore the erosion of purses, which leads to the inevitable erosion of the industry in Illinois. So I thank you.
Thanks, Mike. Dominic, do we have anyone else before we turn it over to the commissioner comments or questions?
Mr. Chairman, this is John Gay, if I may, for a second.
Sure.
I just wanted to clarify something that Mr. McCaffrey said, and I don't think this was the intention to insinuate this, but when he stated that part of the law was not being followed, I just wanted for the record to clarify that he's talking about things that are outside the control of the racing board, i.e. the appropriation to the Department of Agriculture done by the General Assembly, which is not within our purview. Right, David?
100% correct. If I misspoke, I hope I didn't. But yes,
I just wanted to clarify.
Oh, yes, good. Yes, it's the third part of the law is clearly up to the legislature. It's very clearly stated that they should pass an appropriation that equals the amount of recapture that reimburses it, and it's clearly not being done. But that has absolutely nothing to do with the Illinois Racing Board.
Thank you for that.
Thank you. Is there anybody else from the ITHA that's going to provide testimony? David?
No, sir.
Thank you. Chairman, with that said, a representative from Arlington is available and has already been sworn in. Tony Petrillo.
He wishes to speak.
Please unmute yourself. There you go.
Yes, thank you, Mr. Chairman and Director DCR. I just would like to mention that we talked about this recapture now for many years, and if it were just simple as those three components that were stated earlier, we might look at this differently. But just for example, as part of this law, whenever one of the racetracks opens up an OTB, they work in generations, or there's an escalating scale in which revenues from our operation more goes towards the purse account than the track actually makes. So there's some offsets there, and regarding the payment schedule that the ITHA is seeking. First, I would say why Arlington should not be treated differently than any other racetrack in those terms, other than the agreement that we have with the horsemen. Arlington has voluntarily capped, prior to this year, has capped or put a ceiling on recapture of $4.5 million that was accepted and signed off by the horsemen's organization in our contract, and it calls for those monies as well as the monies that are taken from the purse account to fund the ITHA's operations that to be taken out before we calculate daily purses. So, we do have an agreement in place on the payment schedule with the horsemen, and we cannot control the results of the pandemic as we could not this past year. We have accepted 68 days of racing, fully intend to run those 68 days of racing. We are licensed, we are regulated, by the Illinois Racing Board, if there is a failure to run those dates without the approval or reduction of those dates by the Illinois Racing Board, we face severe penalties. I believe we could be penalized up to $10,000 a day. So, to accept something different that has been done in the past insofar as Arlington being treated differently than any other track or any other economic circumstances that would arise out of the pandemic, I don't think that would be in the best interest of racing and to set that type of precedent. We are accountable to the Illinois Racing Board, and any failure to abide by the contractual obligations that we have or regulatory obligations that we have insofar as accepting the race dates hearing and accepting the dates and paying the fees associated with those dates would be an unfair to Arlington.
Is that it, Tony?
Yes, sir.
Okay. Do we have anything else then from them? Anybody else wanting to speak before we go to the commissioners? Dominic, do you have any?
Chairman, unless the board would like to hear from Hawthorne and or Fairmont, they're both representatives, they're both available. Should the chair call them?
If they're wanting to, that's fine. Or if any other commissioner wants them to, that's fine. Just anybody can speak. It's pretty much an open policy here to hear people that want to be heard.
Certainly, Mr. Walsh, would you like to testify to anything?
No, nothing to say.
Thank you. Ms. Helton, would you like to add testimony?
No, thank you.
Thank you.
Okay, let's turn to the commissioners. Do we have any questions from the commissioners or comments regarding this issue? Hearing none, we have a matter before us. Do we have a motion? Do we have a motion?
This is Leslie Sandberg. I'll
Yes.
move that we take action on this agenda item.
Okay, we do have a motion. Do we have a second?
This is Marcus Davis. I'll second.
We have a motion and a second.
Mr. Chairman,
Yes.
this is John Gay. I just want to clarify Commissioner Sandberg's motion is to approve the certification amounts presented that the staff recommended approval on. Is that the correct motion?
Yes, it is, John. Thank you.
Thank you.
Okay, so we do have a motion and a second. It's been clarified as to the intent. Please call the roll.
Chairman Beiser.
Yes.
Commissioner Burr.
Yes.
Commissioner Davis.
Yes.
Commissioner McKelvey. Commissioner Reyes.
Yes.
Commissioner Sandberg.
Oh, yes.
With a vote of 6-0, the motion passes.
5.
Thank you. Agenda item number 5. Request submitted by Arlington Park to amend the 2021 stall application to require general liability insurance pursuant to Section 1314.150 of the Illinois Racing Board adopted rules. Section 1314.150 of the adopted rules implementing the Illinois Horse Racing Act of 1975 states no racetrack operator shall allocate stalls except pursuant to a written stall application and agreement, the form of which shall have been approved by the board. Arlington Park is proposing to add Clause 34 to the existing stall application. 34. Insurance. Trainers shall maintain at all times general liability insurance with coverage no less than $1 million per occurrence and $2 million in aggregate. Trainers shall, prior to admission to the Arlington Park Racecourse facilities and at any time upon request by Arlington Park Racecourse, furnish a certificate evidencing proof of insurance coverage in accordance with the requirements set forth herein. Failure to maintain adequate insurance may subject trainer and or owner to multiple and substantial risks, including being excluded from Arlington Park Race Course premises. All certificates of insurance shall provide that Arlington Park Race Course shall receive at least 30 days advance notice by the insurer of any cancellation or material change in coverage. Owner and trainer indemnify and hold Arlington Park Race Course harmless against any claims, liabilities, judgments, or costs, including attorney's fees, arising out of the trainer and or owner's failure to obtain insurance as appropriate and as may be required by law. Chairman, there's a representative from Arlington and the ITHA who have both requested to speak on this agenda item.
Okay, let's hear from them.
Would you like Arlington or the ITHA to speak first, Chairman?
Arlington's fine. Yeah.
Thank you. We seek to add these provisions which have been common business practices in most businesses in this state, as well as many tracks taking this on. And this does not change any agreements or provisions that we have with the Horsemen's organization in our race meet agreement. From what I understand, the ITHA has signed off on the requirement to have the insurance, and the indemnification that we're seeking, and maybe there's a better way of wording it, is only if the owner or the trainer has stated and provided proof that they have the insurance, and then something happens, and then they actually don't have it. So it is separate from the provision that we have in the agreement is a totally a blanket indemnification. We have an agreement that we will not have this blanket indemnification. So this is different and only would apply to a trainer that states that they have the insurance, something happens, and then they don't have it. Only in that instance do we ask for the indemnification, or does this indemnification clause apply? So I would equate it to, some of these similar laws, the state auto insurance law. If you state that you have insurance and then you get an accident, you go to court, you actually don't have it, you would still be liable. There has to be a proof and a burden of the insurance and an acceptance of liability. If you do not, you state that you do have it and then you don't actually have it to cover the expense of something that is due to the negligence of that individual trainer and then not having the insurance that you have certified.
Okay, do we want to, if you have anything else, Tony, or we'll turn to the horsemen for their
No, sir, thank you.
Okay.
David, will you be speaking on behalf of the ITHA?
Yes, and Glenn Berman.
Okay,
also.
Mr. Berman, just remember when you do speak, remember that you need to be sworn in. Please proceed, David.
Thank you. I don't think this needs to be dragged out too long. We were given a proposal a week or so ago, and it contained several things. This last iteration is sort of what it has been reduced to, I guess. And we as a board discussed and considered the whole general liability issue. It has never been a requirement. General liability has never been a requirement for a stall application in the past at Arlington. Well, I should never say never. At least for the last 10 years. but our board of directors, the ITHA board of directors, saw some benefit to this and agreed, even agreed to the amounts that Arlington were requesting, which was $1 million per incident and $2 million in the aggregate. So basically, we agree with the very first couple of sentences that were read, and we disagree with the indemnification part of it. First of all, there's a very explicit reference to indemnification clauses in our contract, and second of all, I just don't think it's necessary. If a trainer purchases a policy and provides it to Arlington, which is what they're asking for and which is what we've agreed to, that should be enough. Any policy I've ever bought before has been purchased up front, so I'm not even sure what the worry is. Maybe if it's that the trainer canceled the policy or something halfway through, I don't know. But there is a clause in the current stall application that speaks to a liability policy for personal injury, and in that clause there is no such mention of indemnifying the track if the policy disappears or whatever happens to it. It just says that the applicant shall, the applicant shall have horses on the grounds, and such certificate shall contain a clause providing that such policy shall not be canceled without 10 days prior notice to Arlington. There's no mention of indemnification. There's no mention of hold harmless. So basically, we agree with the benefit of general liability. We've agreed to the amounts that Arlington has put forth. It's just that last sentence or two regarding indemnification that we have a problem with. Glenn Berman is our attorney, and can probably explain it a lot better than I.
Good morning.
Should I swear him in?
Yes, please.
Do you solemnly swear the testimony you're about to give in this call will speak the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Good morning, Commissioners. My name is Glenn Berman. I'm an attorney. In the past, I worked with the ITHA in a similar capacity and as executive director, and I've been executive director of other horseman organizations. This language that the board of the ITHA didn't initially agree with any modification of the stall app. The stall app, any modification to the stall app, as Mr. Dominic said at the outset, should have been done at the organization license application time. But now they're coming in after the fact and saying, okay, now we want to change it. Here it is. Here's this language. And as David stated, the ITHA board recognizes value both to the trainers and the racetrack for the trainers to have a business policy covering them for business liability. So that part they could accept, but adding a hold harmless provision is not only is it a reach from a relationship standpoint, but as David stated, it's directly in conflict with the contract that was just signed 7 months ago, which paragraph 9A says the stall application shall not contain clauses which absolve or hold a party harmless for liability. So in that, it would be a complete contradiction of the current contract. And from a more practical standpoint, if the concern of Arlington Park is that the policy might be there at the beginning but it's not there at the end of the season, as David suggested, there is also a paragraph 6 of the current stall application, current meaning 2020, that has for another policy, and it states that that the policy shall be provided to the racing secretary at the beginning of the season, and it shall contain a clause providing that such policy shall not be canceled without 10 days prior written notice to Arlington. That provision also states that the policy shall cover the entire season and until such time as the trainer removes their horses from the premises. So no reason to reinvent the wheel here. This similar language that protects Arlington from a canceled policy already exists, and that can be mirrored. It got kind of late in the day to keep negotiating since the discussion just started the other day on this. But that would suffice if the true concern is just that a policy is getting canceled. When you add hold harmless language, and especially the way Arlington's doing it, not only are they asking the trainers who are expected to get this policy to be held harmless, but the owners of the horses are hold harmless. When you add a hold harmless provision, that's indemnification and liability issues. And although Arlington may see it only as hold harmless for the lack of the policy, I'd say that an insurance company that is forced to defend a claim is going to look at a hold harmless agreement a little differently. And Arlington's insurance company might say, wait a second, we got a hold harmless. We can go get the owners to stand in our place on a liability issue. So, but there's no reason for this because A, it's prohibited by contract, and B, there's another way of solving this problem. I don't expect there to be a negotiation on how to solve it right now in front of the board, but what is being stated by Arlington is their concern can be resolved. That's all.
Mr. Chairman, this is Mike Campbell. Could I speak, please?
Please do.
Okay. We attempt to be cooperative. It's in our best interest as horsemen, owners, and trainers, and that's the group that we represent by our bylaws. That's who we're elected by, or I am anyway. But in an effort to be cooperative, and certainly that first sentence is not too great of an ask. It makes sense. It protects the owners and the trainers. But I do not have the authority. My organization does not have the authority to go so far as to hold harmless the track at potentially the total risk of the owners and trainers. We don't have that authority. That would be a matter of individual liability. And so, while we're willing to go along with that first sentence, the rest of that ask is a bridge too far. And we feel it's entirely unfair to restrict our membership to that type of policy, which can be interpreted in any number of ways, when in fact, the first sentence satisfies our basic wish. So with that, I agree with everything that Glenn and David testified to, and I believe that the first sentence and our recognition of that is good enough. Thank you, sir.
May I say one more thing? The language suggested by Arlington, in addition to being violative of their contract, includes the owners, and it says hold harmless for failure to obtain insurance as appropriate. $1 million might not be appropriate for a person who gets paralyzed. So, there's, as I said, insurance companies look for ways out of paying off on claims, and this type of language shifting the burden and making the owners and trainers responsible to hold harmless Arlington Park is totally inappropriate.
Okay. Any other people wishing to comment before we ask the commissioners to give their input?
Chairman,
looks like Tony's trying to speak. Tony, you're muted.
Yes, Mr. Chairman, if I may have a moment to respond.
Sure.
At your leisure. Oh, may I proceed? I'm sorry, I didn't.
And I said, it's fine.
Okay. Oh, yes, sir. Thank you. Well, first, I guess there is a difference of opinion whether this applies to the agreement that we have in place with the Horsemen's Association. Our interpretation and understanding and opinion of that is a blanket indemnity. This is a very specific indemnity that if the trainer has represented that they do have the insurance and that they don't, then we are asking for that indemnification. That's really not out of ordinary business. The ITHA, we've heard today that they've agreed that this is necessary, but what is the deterrent not to cancel that policy and misrepresent that you do have insurance, and that then the track could be held liable for this? This is not this is not harmful. If they have the policy and it continues, it's not going to be an issue. So with and I just want to mention that these are business decisions that belong to the track. There is nothing that requires the consent and approval of the Horsemen's Association, and we're not asking for the ITHA to sign off on this indemnity. This is the individual trainer that signs the stall application, and as a private business owner and operator, they would agree to those conditions. So it would be independent of the ITHA that can't accept the indemnity on behalf of all the members, but it would be the individual trainer. So that's what we're trying to accomplish, is to set the deterrent for submitting the policy and then canceling the policy and not having the insurance. And then again, as the ITHA has stated, they agree with having the policy in place. So if everybody keeps the policy in place, there's really not an issue by including the indemnification clause, under which they would only have the indemnity if they purported or if they represented they have insurance and then they don't have it. We're not asking for a blanket indemnity.
May I respond?
Sure.
My suggestion is this language needs to be worked on. If what Mr. Petrillo is stating is all that they're looking for, then they should say it. You don't put language in a contract type agreement involving insurance and hold harmless and indemnity and hope somebody else interprets it the way you think it is. As far as, and like I said, there's already language in the stall app that would protect Arlington from this situation. The trainer would have to provide the policy at the beginning of the season, covering the whole season. A provision in there that the insurance company has to give notice if there's cancellation, give them 10 days notice. And when Arlington receives that notice, they would do what they would do with the other policy, which is either make sure the trainer comes up with a new policy or pays their premium or whatever, or tell them to leave. That's the prerogative of the racetrack. If you don't have this policy, you don't come on board, or you have to leave. To insert and to say that the ITHA, this isn't their purview. The ITHA represents the owners and trainers. This is the only chance that notice didn't go out to all the owners and trainers that Arlington was trying to put such a hold harmless agreement into the stall app. And these are the type of agreements that trainers sign. The owners never even see them. So to make an owner out there who has a horse at the track and then find out that somebody fell off and got paralyzed, and they've got a hold harmless, and it doesn't say for $1 million, it says insurance as appropriate. That could be tens of millions of dollars, and Arlington's insurance could say you didn't have appropriate insurance. So there's way more issues here than what Tony is suggesting, and I suggest that this problem of the policy lapsing can be solved by having specific language regarding a policy lapsing.
Anything else, Glenn?
That's it.
Okay.
Mr. Chairman, there is a timeliness issue on this. Our stall applications do have to get out here shortly, be printed, and do have to get out here shortly. I think what I'm confused about is now, what I'm hearing Mr. Berman say is that 6 gives us all the protections that we seek. So not having this spelled out in the stall application of what is required, and I'm hearing that this is just kind of a blanket, we can continue with provision 6 that requires their certificates of insurance, but without letting the individual trainer know that, here's the minimum requirements. They could come in and not have the minimum requirements. We could say, oh, I'm sorry, go back and visit your insurance and have your insurance company reprice this for you. In the meantime, stall applications are due. We're collecting these stall applications, and they may not meet the qualifications and will miss the deadlines that we have for the stall applications. So there is a timeliness issue associated with this, and providing the clarity of what is required and the acceptance of, if you say you are going to do what's going to be required and you don't do it, there has to be some type of deterrent that's set to advise the trainer. And this is how it's always been provided notice. The stall application has provided notice to trainers when there are changes. We use this as well as the condition books that the trainers do rely on to get information. And to my surprise, I think that there are a larger number of trainers that do review this stall application than is being led on to be believed here today.
I've got a response. A simple, if you're done, Tony. The simple solution here is just to amend paragraph 6 and just add the first sentence. In addition, you've got language there that talks about a policy that has to be provided by the trainer's filed certificate of insurance for $100,000 minimum liability insurance, and just add, trainer shall maintain a general liability insurance with $1 million and $2 million. That first sentence, and make that part of paragraph 6, and the rest of it takes care of it.
Well, we stand in disagreement with that. Again, if there's no deterrent, if they don't understand that you cancel this policy and you're not willing to accept liability, we just don't understand why, if there's support for this policy and the necessity for it, why, and it's going to be intact throughout the race meet, what would be the problem of having the indemnity included?
For all the reasons I stated, and by the way, the terms and conditions of the stall app are terms and conditions that are put upon horsemen, and if they don't follow any of those terms, the track reserves the right to exclude somebody from the premises, which they use on occasion when somebody doesn't follow the rules. So it's inherent in their power. If you don't follow the terms of the stall app, they can boot you out. And the language is already there for the $100,000 policy, and there's no indemnification if they don't have that $100,000 policy. There's no indemnification by owners. There's no hold harmless on liability. That's a far, far, far different animal here.
Well, if the policy's in place throughout the race season, we don't understand what that problem or that issue is with the accepting that indemnity. Otherwise, what's the use of the policy? What's the use in having it? Again, the trainers, if there's anything that they don't like in this policy, they do see this at other racetracks across the country. We submitted a list to the board with a growing number of racetracks, and they don't have to accept those conditions, but they do have the right to choose where they do want to race and under what conditions.
Except for the fact you've got an agreement with the ITHA not to put such a hold harmless agreement in the stall app, specifically in the stall app. That's what the 9A of the current contract is. It's a 2-year contract. If you want to raise this issue, this is something that should be saved for 2020 2022 season.
Well, again, this is separate from that. That is not the blanket indemnity that's described in there. This is the indemnity if you say that you're not going to do something, that there is a consequence to that.
It says the stall app shall not contain clauses which absolve or hold a party harmless for liability. There's nothing about
Right, that is that's the blanket, Glenn, and that's, you weren't around when we negotiated that portion of the agreement, but that's what it was. It was a full indemnification, not the indemnification if you state that you are accepting responsibility. You do have the insurance, and then you don't have the insurance.
Okay.
Chairman Geiser, could I make a comment? This is Leslie Sandberg.
I was just going to ask for commissioner comments. I have some, and then I will have a statement too. So go ahead, Leslie, you're first.
Well, I'm just making an observation because as a business owner myself of many years, I've run up against this issue that Tony's kind of calling out, in that someone who's supposed to have insurance turns out not to have insurance. And it is problematic. I get that, and I'm assuming somewhere that's happened. But both Glenn and Tony have referenced the contract suggesting that they're receiving certificates of insurance. And I'm not officially an insurance agent, but I can tell you that what we ended up having to do as a remedy for exactly that problem was asking that we be made additional insured, not certificates of insurance, because it's a big difference. And if you're an additional insured, which is a $20 fee or something, $25 fee, the insurance company must notify you directly if the policy lapses or is canceled for any reason. So you don't rely on anyone, in this case a trainer or an owner, to tell you the policy has gone bad. You'll find out directly from the insurance company. They're required to notify you. So maybe the answer is simply that's kind of your amendment. Instead of requesting certificates of insurance, ask to become an additional insured. I don't know. That's just something we did in the past, but that's all.
Thank you. Any other commissioners would like to have questions or comments? Okay, this is my own personal opinion. It gives me, I'm sensitive to what Tony Petrillo said about it's time sensitive. We all live in a world where there's deadlines and we have to try to work around them as best we can. But I'm extremely sensitive when there's an issue that deals with contractual obligations or contractual language, or however you want to term it. I'm hearing that this is interpreted by one side to be part of the contract, and the other side said it isn't. I don't believe the racing board, if we were to act on this request today, that would effectively be putting us in a situation where we're choosing a side on an interpretation of an existing contract. That's not the role of the racing board to be. We don't wear referee stripes when we convene these meetings to a great extent, especially when it comes to a contract. So what I would suggest to the parties involved is, if you insist that this be dealt with today, that's fine. I'm prepared to vote no as it presented now. Or if the time-sensitive nature of it makes it that the time between this meeting and next month's meeting is too great that would cause harm to the process, I'm open as chair to go ahead and having a special meeting, even though it would be, it would be somewhat out of the ordinary, but I consider this an out of the ordinary situation because it deals with a contractual situation. So that's my comment. And if there's any other commissioner comments, let me know now. Otherwise, if there is a motion in a second, like I said, my intent would be as an individual commissioner would be vote no, but I'm open to further questions or comments by the remaining commissioners. Okay. Okay, hearing none, then we will.
Chairman, I'm sorry to interrupt. I believe our attorney, John, if you're still intent on adding anything.
No, not at this time. Thank you, Dominic.
Okay, thank you. Sorry, Chairman.
That's no problem.
This is Leslie Brewer.
Yes, Leslie.
Dan, I'm in agreement with your position on this. Some way we should be able to allow some time to revise the item as it was put. I also would vote no based on what is here. So I see he's trying to maybe tabling this agenda item at the moment and dealing with it expeditiously. Thank you.
And let me just say, too, I appreciate that comment. And Leslie, I do appreciate what you threw out there for consideration. And I did make some notes here that when Glenn was talking the first time, I believe, and Glenn, I'm not trying to put exact words in your mouth, but it seemed to me that you indicated that you felt that this could be resolved with further discussion outside of a board meeting setting. Would that be a correct assessment?
Based on Mr. Petrillo's concerns, yes, we could meet those concerns in writing and make it real specific so that we don't leave this thing open to interpretation. That says what it means. Yes, I think so.
Well, then, so here's the options procedurally moving forward. We could vote on this matter up or down, and then, but the problem with that be if it does not get the required votes, then there's no agenda item at a special meeting. We'd have to create a whole new special meeting agenda, or if we not tabled it, you would lay it over. We could call it off lay it over. We could call it back at a special meeting procedurally and very smoothly. So, if I was making a recommendation, I would not want to take the chance of a yes or no vote at this point until the parties have had a chance to further discuss this and hopefully come to an agreement. But again, commissioners are all welcome to make motions and all welcome to make seconds. But that would be what I would suggest procedurally. Dominic, do you have any comments? I know we didn't discuss this prior to this. I just threw this out. But this issue should not, in my opinion, be decided at this point based on the testimony we've heard.
So thank you, Chairman. We're all in agreement with your perspective on it. We have a better parliamentarian on staff, John Gay. If he wants to add anything to the procedural aspect of your recommendation, I would invite him to chime in.
Sure, thank you, Dominic. Just from the Open Meetings Act perspective, it would depend on if we were to hold a special meeting, we would just need time to put out notice and put out an agenda, and we could do that. Saying when you want to have it. If it was shorter, we could always recess to a date, time, and certain, and work out the same agenda. In order to be a special meeting, we would have to create a new agenda and post it.
Well taken, John. If it's a special meeting, then that's a whole different agenda. So I guess the question then becomes, do we want to, after we have item 6 and item 7, do we want to recess for call or chair, or do we want to vote on this one way or the other? Now, I guess that's the question.
This is Leslie. I have a procedural, maybe this is a John question, but so when the agenda is built, it's based on a request. In this case, I would say it's Arlington Park's request that is the agenda item. Is it possible that if they feel they don't want to perhaps get the vote that they're not interested in getting today, can they withdraw an agenda item for resubmission? Or how does that work?
If there's no motion to be made today, then the chair would just move on to the next motion, the next item on the agenda.
Okay. Thank you.
Mr. Chairman, this is Tony Petrillo. If I may make a comment, please.
Please.
Would it be to have the language that the ITHA feels is appropriate approved today, and then so that we get the clarification and work on the. And I don't know if there is a provision or one portion that maybe I missed in hearing the ITHA speak to that include in the language that the ITHA has felt is appropriate, include the language that if the trainer does not have the policy or cancels the policy, that we can remove them from the track or from the premises, only in that, at least why I'm interpreting what Mr. Berman said is that, it sounds easy to be able to just dismiss someone from the grounds, but it's in the past it has not been that easy. There are ministerial remedies that could delay that, and there's also other legal remedies. He did mention that if they do not have the proper insurance, we could just remove them from the track. So including that sentence that is part of the proposed language, along with what the ITHA has signed off on, maybe that's one way to proceed today while we contemplate the levity of the indemnity clause, so that we could at least get our stall applications out, and then if we have to, get an amended stall application out. Just based upon the timing, we need to get these stall applications printed and in the mail within the next 7 to 10 days. With the Postal Service being as slow as it is, we need to be able to get these out so we could get them back by March 1st. And, any delays, we just want to be able to get these out, get them back, and start allocating stalls and seeing what horse population is going to be out there, so that we understand when we could start writing our condition book, what type of conditions we're going to be able to write for.
May I respond to that? When I suggested that the racetrack always has the authority to expel someone from the track, that wasn't meant to negotiate changings to language here. That was just stating that that's an inherent power that they have, and it was in response to Mr. Petrola stating that there was nothing they could do if people had their policy canceled. I do like the idea of adding Arlington Park as an additional insured. That solves, in my mind, from my experience, that solves the problem here. And I think that I could probably speak for the ITHA, and David could confirm this, that we would be okay with that very first sentence. Trainer shall maintain at all times general liability insurance with coverage no less than $1 million per occurrence and $2 million in the aggregate, with Arlington Park as an additional insured. That gets it out there. It gets them the notice they need. They'd have to be notified if there's cancellation, as the director suggested, and probably don't have to go any further than that. But at least it gets it on there for the stall app.
Why don't we do this? I appreciate those comments. Rather than go back and forth in open board meeting right this second, why don't we take a 15-minute recess, and the people that are the interested parties, the horsemen and the Arlington, if that is agreeable, try to get back to us in that 15-minute recess when we come back into session, and then we can craft an amendment to that effect. But rather than have it here and there now, why don't we take a 15-minute recess, and then people will come back. Let's see what time it is. 11:40. Let's go ahead and come back. Or let's go up 11:45. Make a 20-minute recess, and then we will, hopefully you guys worked it out in the meantime. Is that okay with Dominic?
Chairman, thank you. I would appreciate that. The parties, hopefully can get together now. If we advance, if the board sees fit and advance to a recess, I would recommend everybody keeping the line open as you are. Mute yourself and go to a different room or different location to speak. so we don't disconnect you from the WebEx. And in terms of broadcasting, we'll make remedies with Springfield as to when to start and stop. So thank you, Chairman.
Okay, so then we will be in recess until 11:45 for the racing board meeting.
Thank you.
Mr. Chairman, this is Mike Campbell. Would it be advisable to have a member of staff on this discussion too, so that memories don't fail us?
I think that would be a good idea if Dominic would assign someone to be part of that discussion.
Okay, thank you, Chairman.
Not part of the discussion, just part of as a listener.
Correct. Thank you. John?
It's fine, but whatever we approve is going to be put in writing, so, but I'll sit there and listen.
Correct.
Okay, we'll reconvene at 11:45.
The record to be open. We'll make this brief statement.
Okay.
Let's go back into session for reasons of announcement.
Okay.
Thank you, Chairman. At the request of the parties, they wish to ask the chair and the board for a noontime beginning to the session, so as to reduce in writing what their discussions are and distribution to the commissioners and chair.
Okay, the chair will order that we will go back into session at noon. Then.
Thank you.
You're welcome.
Call roll.
Chairman Beiser.
Here.
Commissioner Brewer.
Perhaps he's unmuted. Donnie, can you please check on that? Commissioners, please unmute your telephones or computers to respond to roll call. Thank you.
Commissioner Brewer.
Please unmute, Commissioner.
This is Les Brewer. I'm online.
Okay. Commissioner Davis. Commissioner Davis. Commissioner Davis, did you respond? I could not hear you there. Commissioner McKelvey.
Yeah, I'm here.
Commissioner Reyes.
Commissioners, please remember to unmute your telephones or computers, whichever one you're using for this call.
Ben Reyes is here.
Can you hear me now?
Commissioner Davis.
Yes. Commissioner Davis. Just Commissioner Sandberg.
I'm here.
Okay, we have a quorum.
Bob, for the record, can you please reestablish roll call one more time? We had significant interruptions. If everyone's back on, I apologize.
No problem. Chairman Visor.
Here.
Commissioner Brewer.
Commissioner Brewer's is muted once again.
Here. Leslie Brewer here. Commissioner Davis.
Here.
Commissioner McKelvey.
Here.
Commissioner Reyes.
Here.
Commissioner Sandberg.
I am here.
All right, we do have a quorum.
Thank you. If I may, Chairman, you would request a recess to review this agenda item. At recess, the parties convened, and the board has received language. General Counsel John Gay is in receipt of the language, and we can proceed upon your approval.
That'd be fine. Howard, will you want to read this into the record? This agreed upon language.
Yeah, I'll go forward. So, thank you, Mr. Chairman. I had a very productive conversation with Mr. Perchillo, Mr. McCaffrey, Mr. Berman, in which they have come to an agreement on language that meets the goals stated earlier. I will read that into the record now. It's I know, just for the record, this language has been emailed to all commissioners, so you should have it in writing in front of you. But I'll read it for the record. To be added as paragraph 34, it will read as this: insurance. Trainers shall maintain at all times general liability insurance with coverage no less than $1 million per occurrence and $2 million in the aggregate, with Arlington named as an additional insured. Trainer shall, prior to April 1st or upon submission of stall application, furnish a certificate or certificates to Arlington evidencing proof of insurance in accordance with the requirements set forth in this paragraph. And that's the end of the agreed upon language.
Okay, and then for the record, we have one representative of Arlington and one of the horsemen. Just going on the record saying that this is agreed upon.
Yep, this is David McCaffrey, and yes, we basically adopted Commissioner Sandberg's idea, so she gets the gold star, and we're in agreement.
Thank you. Tony?
Arlington is in agreement.
Thank you. So, we have, it's been read into the record, this agreed upon language. Do we have any comments or questions from any of the commissioners? I would echo Mr. McCaffrey's comment about Leslie. Thank you for suggesting this. Appreciate it. Hearing no comments or questions, is there a motion to, John, do we have to move to accept as amended or just move for this language? How would you suggest that?
You're muted.
If a commissioner were to make a motion, I would suggest that to approve this, it would be to approve the language, the stall application that was just read into the record.
Okay, the commissioners has heard that. Is there a commissioner willing to make that motion?
Well, Leslie Sandberg will.
I appreciate that, Commissioner.
Ben Reyes second. Ben Reyes second.
Okay, we have a motion and a second. Would you please call the roll?
Chairman Visor.
Yes.
Commissioner Brewer.
Yes.
Commissioner Davis.
Yes.
Commissioner McKelvey.
Yeah.
Commissioner Reyes.
Yes.
Commissioner Sandberg.
And a vote yes.
With a 6-0 vote, the motion passes.
Thank you. Agenda item number 6 is Commissioner comments. Chairman?
Commissioner Reyes, would you have any comments at this time?
No, I'm good.
Thank you. Commissioner Davis?
Just very impressed, and thank you for hashing out agenda number 5. And thank you, Commissioner Leslie, for your feedback there. It's very helpful. Thank you.
Thank you, Marcus. Commissioner McKelvey?
I agree. No further comment.
Thank you. Commissioner Brewer?
No further comment.
And Gold Star Commissioner Sandberg?
Well, I'm just going to hang that on my refrigerator.
Okay.
No, I have no comment. I'm really glad you guys were able to come to an agreement, make this move forward.
I agree. I appreciate the members of Tony. I appreciate you on behalf of Arlington and Glenn and Dave and Mike and the Horsemen coming together and getting this worked out. I appreciate it on behalf of the entire board. Thank you. Dominic, can you tell me, is Lisa Helton from Fairmont still on our call?
I see her still on. Ms. Helton, if you can unmute yourself, I think the chairman would like to hear from you.
Yes, I'm here.
Hi, Melissa. This is Dan Beiser. As you know, your track is located in my neck of the woods and Commissioner Brewer's neck of the woods. And I understand as part of the requirements to the racing board, you submitted some correspondence regarding a stakes race at Fairmont for next year. Is that accurate? And can you talk about that?
That is correct.
I think this is a bit of really good news for horse racing and for our area especially, but for horse racing in Illinois. If you'd like to, I don't want to be the one to make the announcement, but if you feel so inclined, or I would appreciate you filling in the rest of the commissioners and whoever else might be listening on what you've requested.
We have requested to pick August the 28th and bring back the St. Louis Derby. We have partnered with FanDuel with our sports book that demo will begin actually on Monday for. So that race is part of our contract with them to bring that back, and then I've asked for permission to set aside August 28th for that date.
I really appreciate that, and I want to acknowledge all the hard work that you've put in since you've come on board. Acknowledge Mr. Sturritz, Jim Watkins, all the people down there that have made this thing a success and moving forward, and we're really looking forward to it. And hopefully if the conditions around COVID have changed dramatically between now and then, I would like to be down there with you, and I would like to invite all members of the racing board to be there for this occurrence that hasn't really happened, I think, since 2006, correct?
That is correct.
Yes. Well, we appreciate that bit of good news, and we look forward to working with you on not only in that, but in the future with horse racing down at Fairmont.
Thank you. We're so excited to bring it back, and look forward. Hope you all can attend down there. So mark that date, August 28th.
Will do. Appreciate it. That's all the comments I have. I think item number 7 now is the approval of the last month's board meeting, or November 17th, board meeting minutes. Do we have a motion for approval?
Ben Reyes, move.
We have a motion by Commissioner Reyes and a second.
I'll second. Marcus Davis.
Commissioner Davis, please call the roll.
Chairman Beiser.
Yes.
Commissioner Brewer.
Yes.
Commissioner Davis.
Yes.
Commissioner McKelvey.
Yes.
Commissioner Reyes.
Yes.
Commissioner Sandberg.
Oh, yes.
With a vote of 6-0, the motion passes.
I want to, again, just reiterate to everybody involved, thank you for bearing with us today on this little bit of an extended board meeting. Again, appreciate all the parties involved that were able to work out their concerns so we can move forward. And, again, appreciate everybody participating under the circumstances that require us to meet remotely. Thank you very much.
Chairman, before we adjourn, and also on a personal note, I would like to personally welcome back Mr. Berman to Illinois. He had been separated for a bit there, in a different jurisdiction, but he adds value to Illinois racing, and we're happy to see him return. Welcome back, Glenn.
Thanks, Dominic. I appreciate it.
Thank you very much, and yes, welcome.
Thank you.
Anything else, Dominic?
That's it on our end. If John has nothing further, we can move to adjourn today's meeting.
Do we have a motion to adjourn?
I'll move.
Commissioner Davis has moved to adjourn. Do we have a second?
It's Leslie Sandberg. I'll second.
We have a motion and a second. Call the roll, please.
Chairman Beiser,
Yes.
Commissioner Brewer,
Yes.
Commissioner Davis,
Yes.
Commissioner McAlvey,
Yes.
Commissioner Reyes,
Yes.
Commissioner Sandberg.
Oh, yes.
6-0 vote, motion passes.
Okay. Thank you, everyone, for participating. We'll talk to you soon.
Thank you.
Thank you.
Thank you.